Hey everybody, Bill Sack here, Director of Legal Operations with the Second Amendment Foundation. It now appears that your friendly neighborhood staff attorneys will once again be knocking on the Supreme Court's door next term. The case is Bianchi v. Wilkinson, our challenge to the Maryland assault weapons ban. Now, my astute staff members will be saying, but Bill, didn't we file a petition for cert on this case already, and SCOTUS declined to take it? Well, yes, that's true, but the case was then up on a special type of petition review called a petition before judgment, asking the Supreme Court to take the case before the Fourth Circuit Court of Appeals, which had been dragging its feet for nearly a year, had rendered its en banc decision, essentially asking the High Court to leapfrog over the appeals court. It's an extraordinary remedy, and we knew that it was a long shot, but it was still worth doing and keeping the pressure on the Fourth Circuit. Well, now, as of last week, we finally have the Fourth Circuit Court of Appeals en banc opinion. And unfortunately, it's just as bad as we figured it probably would be. The court relied heavily on an ill-conceived distinction between, quote, military arms, unquote, and those in the minds of the Fourth Circuit's majority that are appropriate for self-defense use. Obviously, we know that such a distinction runs completely contrary to both Heller and Bruin, and spits in the face of the Supreme Court, not to mention us peaceable gun owners. The good news is, however, now the path is cleared for us to once again file a petition for cert with the Supreme Court. And now the court has every reason to consider the case truly on the merits. You can keep an eye on all of SAF's social media, as well as on the new and improved SAF.org for updates on Bianchi and the other 60-plus cases your SAF legal team is fighting on your behalf. I'm Bill Sack, Director of Legal Operations with the Second Amendment Foundation.